behalf of Mr. Sawyer, who is approaching the podium. Excited to be.
I understand there's a plea, but I don't form it yet. That the defendant will be pleading no contest to an added count to malicious destruction of building, less than 200. The 93-day offense upon a successful plea to that added count 3. Counts 1 and 2 would be. Is there an amended complaint?
Judge, we did have, sorry.
North Dakota law. Truth speaks louder than excuses. Justice begins now.
Sorry, Judge. You did, we're planning to file an amended complaint that this case gone to preliminary examination. That being adding count 2 malicious destruction of building. Just adding count 2 malicious destruction of building for between $1,000 and $20,000. And we would actually have gone to preliminary examination, dismissed count 1 outright.
Okay, well, then we'll have to start this way. Mr. Feaster, you acknowledge receipt of the new information?
Yes, Your Honor.
All right. You waive its reading?
I do, Judge. I'm sorry.
And how does your client plead?
Judge Simpson enters the courtroom, and silence commands respect.
Being standing mute, court will enter not guilty plea as to count 2. All right. And now there's a plea agreement.
Yes, Judge.
In which the defendant would be pleading no contest to an added count 3 of malicious destruction of a building. A 93-day offense. Upon a successful plea, counts 1 and 2 would be dismissed.
That's correct, Your Honor.
May I have him sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name.
Jeremiah Sawyer.
All right. Mr. Sawyer, it is this court's understanding that you're going to be pleading no contest to the charge of malicious destruction of a building under $200. That is a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court cost. The fine could be increased at 3 times the value of the property, which is damaged. If that's greater than $500, that becomes the max.
The defendant stands before the judge, facing the weight of his own choices.
He is.
Yes, sir.
Let me explain 2 things about it just to make sure that you understand. The first thing you need to understand is that it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, sir.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, sir.
All right. Basis for the no contest plea.
Civil liability, Your Honor.
All right. So, sir, to that charge, how do you plead?
No contest.
You understand that by pleading no contest, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form. Is that correct?
Sir.
Any question regarding any of those rights?
No, sir.
You'll see a copy on the podium. Look at paragraph 5. Those are your rights, which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or?
A plea of no contest, neither guilty nor innocent, but the truth will decide.
All right. Was it probation you were on?
Probation and parole.
Both?
Yes, sir.
Okay. You understand your plea in this case could be considered a violation of your probation and a violation of your parole. You understand that?
Yes, sir.
All right. You understand that if it's considered a violation of your probation, that court could sentence you to the maximum allowable under that other charge or charges. You understand that?
Say it again.
If it is considered a violation of your probation, the other court that you're on probation to could sentence you to the maximum that's allowable under the other charge or charges that you're on probation for. You understand that?
He's saying that whatever judge has your probation case,
Each word spoken in this courtroom carries consequences beyond imagination.
Okay. Yeah. Yes, sir.
You understand that?
Yes, sir.
All right. You understand with reference to your parole, if it's considered a violation of your parole, that you could be sent back to prison to do the remainder of your term. You understand that, sir?
Yes. What's the chances of that though?
I don't know how to answer that. I don't know.
I'm saying like this.
Like we
I
talked,
feel, huh?
like we talked about, it's up to your parole agent. And you said you contact with your agent, and they had a plan for you.
Yeah, but is they gonna like from your experience, right? Is this like,
He can't give you legal advice.
huh?
He can't.
You mean my experience on the bench or my experience with parole?
Like from your experience,
Which one you trying to
dealing with
spin
parole?
something on me? I don't.
Parole.
Go ahead. What?
From your experience from dealing with parolees, right? They be sending them back for stuff like this. This ain't really.
The law listens carefully because justice never rushes. It only waits for truth.
Because I don't know. I don't know what you've been up to. I don't know what you've been doing. I don't know whether they like you.
All right, man. Yeah, we go. Yeah.
Sir, do you understand that?
Yes, sir.
Now, if you want me to, I don't really want to, but if you want me to adjourn it out so you can talk to your parole officer, I'll do that so that you can be absolutely sure what you're doing.
Want to talk to your agent?
I'm gonna go ahead. It's cool.
You're going to go ahead with that?
I'm just leaving guys' hands. Okay, it's gonna be good.
You sure?
It all is anyway. All right. So you understand that by entry of your plea, that those two things could happen.
Yes, sir.
And understanding that, do you still wish to enter the plea of no contest?
Yes, sir.
As probation and parole collide, the defendant learns what accountability means.
It's stated here today on the record to get you to plea.
No, sir.
Has anybody threatened you or coerced you in any manner?
No, sir.
You're doing this voluntarily
Yes, sir.
and of your own free will.
Yes, sir.
All right. Court has been provided and has reviewed Washington County Sheriff's Office report for their case number 25-15008. Any objection to the court having reviewed that report?
No.
No, Judge.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Sir, I do have to advise you that if you commit misconduct between the time of my acceptance of the plea and the time of your sentencing, and you commit misconduct as defined by the Michigan court rules, any sentence evaluation or agreement the court would no longer be bound by, and you could not withdraw your plea. You understand that?
No promises, no threats, only the cold honesty of courtroom.
Threats or other inducements which have led to this plea.
No.
It's on the record, Judge.
All right. And have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes.
You have, Judge.
Court will accept the defendant's plea of guilty or of no contest to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be.
November 12th, 12 noon.
Is this the only thing holding him right now?
I mean, he has a parole hold as a result of this, but just this case, Judge.
Don't I got something sooner, don't I? I have an October day.
We'd appreciate it.
Hello? I have an October date.
You have October 22nd.
Thank you.
Justice has spoken. The courtroom empties, but the verdict will echo forever.
At noon.
Thanks. Thank you very much, Judge.
You're
Thanks,
welcome.
sir.
Bond will continue. Thank you. Oh, they're waiting.
In Judge Simpson's court, mercy is earned and truth always wins.